Hi, thank you for joining us. My name is Bethany McCorkle. I'm the Communication Director for Ohio Attorney General Dave Yost. We are going to hear from the principals behind me regarding a very important topic, EdChoice. I'll let each one of them speak and then we'll open it up to Q&A. Because we have reporters in person and remote, we'll go back and forth on Q&A, but I will let those that are joining us virtually know when it's time to unmute and ask their question. So at this point, I'll let you hear from AG Dave Yost.
Thank you all for coming today. In January of 2022, the newly passed EdChoice program here in Ohio came under a lawsuit by a handful of school districts and several parents alleging 5 different grounds under which the program allegedly offended the Constitution. The normal process ensued, and last month we got a decision from the trial court that upheld the complaint on 3 of those grounds. We do not agree with the decision. That's why they make appeals courts, and we will be filing our merits appeal on Wednesday, explaining in some detail why we believe the trial court erred. However, the news media coverage of this and other matters in the courts, it seems like there's been a lot of lawsuits about a lot of things across the country, have left some folks uncertain about where we stand right now in this program. And it's the middle of summer, but people will be going back to school within about a month. And I felt that it was important, as Chief Law Officer of the state, to take a moment and to clarify a couple of things. One of which is last month's ruling was stayed not by a court of appeals, but by the trial court itself, recognizing the state's important policy setting interests here and putting her ruling on pause while the appeals court process unfolds. What does that mean? That means EdChoice is the law of the land. It is funded, it is operational, it is available for Ohio parents. And I want to urge all Ohio parents to carefully consider what's in the best interest of your child. Some people will find a public school the proper venue. Others will find a private or a charter school available. The voucher program is there. And I want to clarify that nothing that's happened legally changes where we are. I mentioned that we will appeal on Wednesday. I'd like to just add that while we will talk about the substance and the law in our appellate brief on Wednesday, there is really good precedent upholding the things that were found unconstitutional. And again, we will go into that more detail in our actual filing. I feel very confident over the course of this appeal that the legislature's action will be found to be lawful, constitutional, and that it will continue to operate in Ohio into the future. Bottom line, it is the law of the land for the 25-26 school year, and we encourage people to make the best decision for their children. Now I'd like to call on my colleague, Matt Huffman, the Speaker of the Ohio Health, for his remarks. House.
Yes, thanks. Thanks very much. Thanks, Attorney General Yost. Well, this is perhaps a little bit of Groundhog Day, I guess, regarding getting sued by folks who are against school choice in Ohio. And I think it was in this case where these plaintiffs personally served a subpoena at the Senate President's office, didn't just deliver it over to an attorney, but decided to have a process server go do it. I think in an attempt to intimidate me or somehow affect the budget process. I think it was this case, but there are so many cases or so many lawsuits that get filed by different entities. And unfortunately, a lot of those are supported financially by tax dollars from local school districts, including this one. And frankly, I think it is a bit of a fool's errand that these school districts are participating in these lawsuits. The U.S. Supreme Court has said on a variety of occasions in a variety of different questions that it is that these various school choice programs, including the Cleveland Voucher Program and other similar ones, are in fact meet the federal constitutional guidelines of the Establishment Clause and the Free Exercise Clause. I'm going to say this phrase in the Constitution one more time for all of my friends who are sitting here. I've said this so many times to them in gaggles over the last 4.5 years. The Ohio Constitution is unique. It's the only constitution, state constitution in the United States, that requires the funding of religious education by the state. The Constitution says the General Assembly shall fund the means of religious education in the state of Ohio. We should ask, is the state meeting its mandate for funding religious education? Because most of the education funding we do in the state of Ohio, by a large stretch, is not for religious education. Now, that's not really what this is about. There's interesting that this trial judge cited a little snippet of that phrase, but we, in fact, have many people, for example, on the religious release issues, trying to fight that, saying that's unconstitutional. Well, clearly it's not by the Free Exercise Clause, but it's also required in the Ohio Constitution. So in many places, we do not fund in any way the means of religious education. There's no alternative in many parts of Ohio for religious education. But that's not really what this case is about. And the case really isn't about what the complaint's about, nor, in my estimation, what the judge's decision was about. This case and cases like it are intended to shape public policy. That's why these cases are often filed just during the budget cycle, or decisions are made the day before we have votes on budgets and all those sorts of things. And my guess is that each time a brief is filed in this case, there'll be a series of news stories about it. And when the Court of Appeals makes a decision, there'll be more stories about it. And then we'll file memorandums in support of jurisdiction. There'll be more stories about it. And we'll talk about it over and over. And the same people will say the same wrong thing, that these program, and EdChoice in particular, is unconstitutional. Because they can, because one common pleas court judge out of about 850 issued an opinion saying that. It's a lot of time, it's a lot of effort to get to the same place that the U.S. Supreme Court and other courts, as the Attorney General has mentioned. So I don't think I have to inform anybody about where I stand on this issue going back to 2007. Those who like what I do about this, which is about 75% of the public, are not going to change their mind, and those who don't like it aren't going to change their mind. But fortunately for you all, we have somebody here who knows more about this and has been more involved in this than I have for a longer period of time. And that is Representative Callender, who has been very involved in the legal aspects of this. I'm going to let him talk a little bit about it, but I think he has, we talked a little bit about this over the last several weeks, and I asked him, well, at some point I'd like for you to speak publicly, so I thought this was a great forum. So I'd ask Representative Callender to come up and talk about his experiences.
We're talking about marijuana?
Yeah, we're not talking about marijuana.
Okay, just checking. Hi, my name's Jamie Callender. I was first elected to the House back in 1996 and began serving in 97. House Education Committee, JCAR. And in my first few weeks in office, the DeRoff decision came down, and that has dominated my life both as a professional lawyer and as a legislator since then. Despite other issues I've gotten involved in, that's always been kind of a core issue. In Ohio, school choice has been challenged in the courts, going all the way up to the U.S. Supreme Court over the years. In fact, the leading national voucher case, the Zellman case, went up, I believe that was 2011, one that decision came down. Looking at our early voucher model, which was untested and we didn't have a lot of parameters as what to do. We were one of the first few states in the country, and us and Wisconsin and Minnesota, I think, were the three states that went up on that appeal. And the U.S. Supreme Court took a look at how we were funding them and what we were doing, and found them constitutional on a federal, and we were found constitutional then on a state level. Later on, we had a challenge to school funding vis-a-vis the charter system and funds going to potentially private operators that were hired by not-for-profit overseeing boards. That was the Congress of PTA case, which also was a very clear sustaining of Ohio's school funding system. There's always been this argument that districts have made, and I won't comment on the validity of it, but that's that they would lose funding if a family chose one of those choice options. Because up until 4 years ago, it was the same line item in the budget. And the funding for that student, wherever their residence was, would go into the district's funding bucket and then be deducted on a public form called the SF3 and sent to the school of choice. With the Fair School Funding Plan that we implemented 3 years ago, and this element we've continued the last two General Assemblies, that is no longer the case. So there is absolutely no validity to the argument that a child choosing a voucher or a charter has any direct impact on the district's funding. And that is one of the key elements of this case. And I'm so glad that the Attorney General is taking this up and has an incredible team of lawyers working on it, to point out the simple fact that they're arguing a funding stream that no longer exists. To say they're losing money for every child that goes is also saying every time a police department buys a new car, every time a hospital gets equipment for a new surgery and uses public dollars, every time we repair a road, it's the same argument. In the state budgeting process, we make choices, and that's constitutionally the job of the legislature. To say that doing one thing impacts another is not a constitutional issue, and this case was incorrect in that, and I'm glad to see that we're seeing the appeal and that there isn't a stay to move forward. But this is just another in a long line of cases, from the 4 DeRolf cases to the Congress of PTAs to the Zellman case, of people trying to challenge it for money, not for the kids. And I think, and I'll add a political statement here, I think it's important that the thorough and efficient clause means making sure every child has access to a quality education and not one size fits all. And it's imperative that for those families that don't fit neatly into the district school, that there are alternatives that are appropriate for that child and best for that family. And that's what these programs are about. And I'm glad that we've got a team of leaders up here that are making sure Ohio stays in the forefront of providing our families those opportunities. There are a number of advocates out there that are making a difference for the children in Ohio. And I want to introduce one of those now, Rabbi Yitz Frankel, who's been at the forefront of protecting our children for a very long time. And I'm proud to call him a friend, along with an expert in the area. Yitz?
Thank you all for coming today. I just want to, just very briefly, because there are better people to speak behind me, but just on behalf of so many of the families that our organization works with that are scared about losing their ability to attend a school of their choice, it's very encouraging for them to know that you have leaders like Attorney General Yost and legislators like the Speaker, like Jamie Callender, that are here to make sure that their interests are protected. Without getting into all the legal arguments, and obviously we have very, very good lawyers in this building that will help make that case on Wednesday, I think it's just important to keep in mind just the human impact of this decision if it were to go through. There's over 160,000 students today that are using one of the 5 state scholarship programs. If that were to go away overnight, I can't even begin to tell you what kind of an impact from a human perspective that would have on these families, but also have a terrible impact on our entire state. Politically, it would have a terrible impact on our public school system. It would have a horrible impact on our non-public schools that have existed and educated millions and millions of students throughout the state. But more importantly, like this program, besides for offering a lifeline to many families, it's a good deal for taxpayers. We spend $17,000 on average for students to attend public schools, and I think that's great. We need to have a strong public school system, and the legislature's invested in that. We spend somewhere between $6,000 to $8,000 for students to attend a private school that their parents choose. That's a really good deal. The second thing is we've had two really important studies that have come out in the past couple of years. One shows that these programs have a positive impact on segregation, which is a very critical issue in our state and in this country. And more recently, there's been a very significant study that's come out that has shown that the outcomes, life outcomes, college attainment that has been caused by the EdChoice scholarship program, both for students using an EdChoice scholarship, but also for students in public schools that are impacted in some way by the voucher program, to have significantly increased outcomes, particularly for black male students. And so I think it's just important to keep in mind as we report on this story, the lawyers can argue all they want, but at the end of the day, there's hundreds of thousands of families that are depending on Attorney General Yost being successful in his arguments. And so now I just want to turn it over to a mother of students that would be impacted if this decision were to stand, Monica Williams.
Thank you so much. Well, I didn't prepare anything to say, but just the impact that this scholarship has helped my children in being at Tree of Life, a Christian private school. It definitely has given my children a wider range of education, and I just hope that everything is in alignment with what God's divine purpose and for this bill to pass. And I'm just thankful and honored to be in the room with you guys and see everyone that is possibly supporting this. And I pray that everything is, like I said, in alignment of where it's supposed to be at.
Well, my name is Aaron Baer. I am the president of Center for Christian Virtue. We also run the Ohio Christian Education Network, which is a network of about 204 Catholic and evangelical schools all over the state of Ohio. I, too, am a Tree of Life parent, as it will, and I can even testify just from Tree of Life, seeing my kids at that school, the number of kids, the diverse student population that are able to access a high-quality education like Tree because of this program. But really, there are two things that are on the line in this case that I think are essential for the future of our state. The first and foremost is religious freedom. As Attorney General Yost alluded to, this case undermines and even outright contradicts some very important U.S. Supreme Court precedent that ensures the right of families to be able to access programs like this for religious education. If you're going to have a school choice program, you cannot discriminate against kids because they choose a religious school. And the judge in this case really went against that very important precedent from the U.S. Supreme Court that's been affirmed multiple times. But in an equally offensive way, this judge also massively is wanting to undermine parental rights and the ability of parents to choose the best education that meets their kids' needs. I find it so offensive that these school districts, instead of asking the fundamental question of why would tens of thousands of kids want to not attend their school for free, but instead go to a different school that in many cases is farther away, instead of asking that question, they would rather use taxpayer dollars to file brief after brief after brief with expensive lawyers to try to tear down this program. Right? This lawsuit has nothing to do with the well-being of students. It has everything to do with maintaining a monopoly. And the fact that we have, as Rabbi Yitz referred to earlier, 160,000 kids that are now benefiting from this program, and more to come in the years to come. This is a great opportunity for them, and I would hope it would be a wake-up call for many of these schools to say, hey, why is it Why is it that many families in our community are choosing to go to a different school? Maybe we're not meeting their needs academically. Maybe we're not meeting their needs morally. Or maybe they just need a different environment altogether, and that's okay. We should be celebrating the diversity of our state instead of trying to push everyone into one monoculture. But ultimately, I think Attorney General Yost really got us going in the most important message here today, is that EdChoice is still the law of the land. EdChoice, and I believe because of the advocacy of this office, because of the leadership in the General Assembly under Speaker Matt Huffman and Senate President Rob McCauley, that EdChoice will remain the law of the land for generations to come, so more families can benefit from this incredible program. And with that, I will turn it over to Tom Fisher, VP and Director of Litigation at EdChoice Legal Advocates.
Thanks very much, Aaron, and thank you, Attorney General Yost. Thanks also to the wonderful team here at the Ohio AG's office, including my good friends, Solicitor General Elliot Geiser and Deputy Solicitor General Stephen Carney, for inviting me today. Before I took up my current position at the fortuitously named EdChoice Legal Advocates, I've served for several years as the Solicitor General of Indiana. And in that role, I had the great fortune to litigate many cases alongside Attorney General Yost and his spectacular team in Ohio. They always set the standard for me and for other SGs around the country that we all tried to match. I'm excited to work with them once again in a critical case of great importance to Ohioans and to all who champion education freedom everywhere. So my company, EdChoice, has promoted education freedom for nearly 30 years. And we have teamed up with the well-known public interest law firm Institute for Justice, which has litigated in defense of school choice programs for that same period, including previously the Cleveland Voucher Program. We have formed together the Partnership for Educational Choice, which represents parents in defending freedom, education freedom around the country, including here in Ohio. Now, the lead counsel for our partnership in this case is Keith Neely from Institute for Justice, but he couldn't be here, so he asked me to attend and offer a few comments. Now, we've heard already from the compelling story of Monica Williams, and that's what this program is about. It's about parents making the best choices for their children and perhaps being able to afford an education they couldn't otherwise. And that's what we bring to the case in our partnership when we represent families in defense of programs like EdChoice. A couple of families that I want to point out to you in particular today. One is the family of Brian Ellis of Akron. He has 3 children, and his children had very negative public school experiences. As often as many children have positive experiences in public schools, unfortunately, theirs were negative. They witnessed constant fighting, rampant drug use, and widespread truancy. The EdChoice program has been an educational lifeline for Brian Ellis and his children. Think also of Catherine Slewinski of Toledo. She's a single mom. She has a son with ADHD, and he attends Blessed Sacrament, where he benefits from special attention. And without the EdChoice program, she would have to send her child with ADHD to a lower performing public school. And the stories like those are numerous. EdChoice has such an amazing benefit on families, and that's the most important aspect of this program that we need to keep in mind. Now, it's been said before by Attorney General Yost and by Mr. Baer. It warrants saying again, parents need not worry about the trial court's decision. They can continue to apply for and receive the EdChoice scholarships while the trial court's decision is on appeal. And we remain confident that we will ultimately prevail when the case reaches the Ohio Supreme Court. Voucher programs like EdChoice have been firmly constitutional in Ohio since opponents unsuccessfully tried to invalidate the Cleveland Voucher Program some 30 years ago. In the decades since, school choice has, like programs in Ohio, have only grown and flourished all across the country. States like Indiana, where I come from, Tennessee, Nevada, Wisconsin, West Virginia, North Carolina, and many others. And we're excited about the opportunity to reaffirm the constitutionality of school choice programs here in Ohio, where it all began. Now, our opponents operate under the mistaken impression that Ohio must choose between a robust public school system and a voucher program. But Ohio can and does have both. What's most important is that Ohio parents retain the opportunity to choose the educational program that works best for them and their children. Our opponents believe Ohio's children are mere conduits for funding for the public school system. They target children's scholarships, hoping that public schools will get that money instead. But they need to remember that Ohio's education system is a system that serves students, not a system where students serve the system. And we have to keep all of that in mind. And I'm confident that as we work together with the Ohio Attorney General's office, we will see victory when this case is over. Thank you.
We'll be happy to take any questions. No questions? Thank you for coming. Oh.
Where in the Constitution is that requirement that the state funds religious education, and is that going to be part of this lawsuit or this appeal?
I'm going to get my phone from Olivia, and I'm going to read it specifically to you.
All right.
But give me about 1 minute.
All right.
All right. Are there any other questions?
So the public schools often say that they have to take every child who comes, and private schools can reject people based on special needs, based on sexual orientation, based on religion. Should private schools using voucher dollars have to accept anyone who applies to their school if the parents truly have a choice?
So that is a policy question that will be developed by the legislature. I'll give Jamie or Matt the opportunity to address it if they'd like.
I'll go ahead and hit on it.
Please step up to the mic.
That is not something that was in this case. That concept has been litigated in the Congress of PTA's case, which is actually challenging the charter system, but that concept is a little bit the same, and in the dicta of that case, it had some language that expressed the differences in, it addressed the standards, the testing, and some of the other regulatory differences between the two. I think many of you actually covered that case, if I remember correctly. So it's not necessarily relevant to this appeal or this case, but it is a matter of public policy, which would be the legislature's purview to choose. I would make note, and I think it's very important, that we have some school districts in the state that are getting well above $20,000 per student, whereas the vouchers are a significantly lower dollar amount than that. So it makes sense that there would be some differentiation in requirements based on the vast difference and disparity in the dollar amounts that were given. I think that the argument that some of the opponents make that those differences are in some way unfair would be a lot more valid of an argument if the vouchers were receiving $25,000, $26,000, $27,000 per student, like some of our districts that are losing students.
So, just to follow up, Judge Page did include that in her decision, that part of the reason it was found unconstitutional was that the schools are choosing the students, right? The parents aren't choosing the school necessarily, because the schools can say, no, we're not accepting you. So how is that not part of this case? I'm generally just trying to understand.
Yeah,
how it's part of this case.
looking at the case, I saw really two major portions, and it was the funding and the requirements. So I guess that would be one of the requirements. I was thinking more the teacher licensure stuff that she was referring to there, I think. But again, there's a huge funding difference. There are grants available, and there's funding available for students with severe special needs, many of which are only available through the district schools and not available to private schools. So to force a private school to accept a student that may have significantly extra costs to educate because of medical or mental conditions, they can't do for the voucher that we're giving. So it is not practical to try to force them to accept those students.
And for the other reasons that aren't cost-related, sexual orientation, religion, those are okay to discriminate based on?
I think there was a voucher case that just came up in out of Oklahoma that addressed some of those issues in the U.S. Supreme Court that you might want to take a look at.
When it comes to the funding, Representative Hollander, you said earlier that, because one of the arguments the judge makes is that the funding for EdChoice takes away from the funding for public schools. You were kind of, I want to make sure I understood you. Are you saying that the budget is all about like funding choices and that it's not unconstitutional for you to just pick different places to put the money? Is that what you were getting at?
I think that's the core job of the legislature, is to make choices, and they're tough choices. Very tough choices, because there's a lot of programs that are deserving. But whether it's funding new ambulances or certain things at certain urban hospitals or library funding, I mean, we make very tough choices. And so to that degree, one choice affects all of the others, because there is a finite amount of money out there to allocate, and that's just a fact, and always will be. That's not going to change. There may have been, although it had been litigated and found not so, 6-7 years ago, when the education funding, when the school funding per child went through the district and then was deducted if a child went to a voucher or a charter school. That no longer is the case, and hasn't been for 5 years now. And so I think that took away any potential challenge, even though the Ohio Supreme Court had upheld that system. I think the fact that after the Fair School Funding Plan, we segregated that funding stream as a separate stream takes away any argument they might have had.
With the Fair School Funding Plan being under review, especially by Speaker Huffman, I know obviously there was some changes that were potentially going to be made. Advocates for public education are saying that they're worried that even more of the money is going to be taken out if the Fair School Funding Plan goes away, and thus the pool will become one.
Well, I think in this budget, there was a lot of saying that it went away. It was altered, but every year we alter the funding plan. And that element in particular, the Fair School Funding Plan, is still in the budget. And I think former Senate President, when he was Senate President, helped us advocate for that and was with us on that and advocated to keep it in this budget. And I anticipate it staying in the budget. Budgets. I won't be here after this year, but hopefully in the future they will continue that. I think it's a good public policy.
I'll answer the other question. There were a couple questions behind, but I would also say the nomenclature that is used where they get to choose they can accept, and there's a difference between those two words. Okay, and I know that those get used interchangeably. And the answer is, if you have a school that's for Muslim children and someone wants to go to the school, maybe because it's across the street or they like the discipline, and they say, but I insist that my child gets a Christian education here, well, that's not why they have that school. And of course, you know, the answer ultimately is that education for tens of thousands of years with human beings has not been done as a large collective across the large group of people. It's families, extended families, and people in communities who know each other. And of course, as we formalized education in the last 100 years or so, we grew into this model. And the model we have now really is only about 30 or 40 years old, maybe 50 years old. In Lima, Ohio, we had 9, before that there were more, but most recently 9 elementary schools. Everyone in Lima, Ohio walked to school because the school was in your neighborhood. Then they combined it into 5 because I don't really know why, what the logic was. So finding a school that best fits a child doesn't mean I want to go to that school. That doesn't mean you get to choose but you can accept the people who you're able to educate. And I admit and agree that that's more of a burden on public schools, and that's why they should be more highly funded than a $6,000 or $8,000 voucher. And the average cost of that has gone up dramatically, especially in the last 3 budgets. It's $16,300. The most expensive school districts are in the mid to upper 20,000s per year per child because they do have those extra costs. That's one of the reasons why we increased the amount of money for the John Peterson and I think autism scholarships to reflect those costs too. But let me read you from the Constitution, which I get to do this right here in the Attorney General's office, so that's a pretty cool thing, right? So Article 1, Section 7 of the Ohio Constitution, the last sentence, I'll read it to you. Religion, morality, and knowledge, however, being essential to good government, it shall be the duty of the General Assembly to pass suitable laws to protect every religious denomination in the peaceable enjoyment of its own mode of public worship, and to encourage schools and the means of instruction. So I'd ask any legislator, I'd ask any member of the public, what are the laws that we were passing, the suitable laws, to encourage religious schools? And the means, which means money, what are we doing for the means of instruction? Now, you could say, well, religious schools get administrative expenses, they get auxiliary services. We have an EdChoice scholarship program. They don't all go to religious schools, but mostly religious schools. But if you're in a small county, say in southeastern Ohio, where there are no private schools at all, what are we doing to help with the means of religious instruction in those communities? And the answer is zero. Now, is there some set of parents out filing a lawsuit over that because Ohio is doing nothing for the means of no, because they don't have the wherewithal to go out and hire big lawyers to file lawsuits. They don't have public tax money to go and file lawsuits that are being used to shut down the other, in some cases, means of religious instruction. So we don't talk about that phrase because the people who might benefit from that religious instruction, the means of religious instruction being provided by the General Assembly as mandated, those folks don't necessarily all have a voice. So I hope as we go forward, we'll talk more about that right that is a fundamental part of our Constitution and in the Bill of Rights in the state of Ohio, and unique to any other constitution in the United States.
Is that part of the appeal? Is that argument being made in the appeal?
I'm not smart enough to work for Dave Yost. I wish I was. But the judge kind of talked a little bit about that in this. So whether that's part of it or not, but I think it needs to be part of the public policy discussion going forward.
Mr. Speaker, it's very unique to have the Speaker and the Attorney General on the stage like this, defending, something like this. I want us to focus on public schools because as Speaker and as Attorney General, the state, the people of the state expect that you will be the people defending public schools, and whatever is lacking, that you should be able to work hard to improve. From some of the speakers, it shows that they are actually not for public school because they feel that public schools are lacking certain things that their children should have. So as the speaker, what are these things that are lacking in public school that should be taken care of by the state that you think the state is not taking care of for you to now want to support this group?
Yeah, well, first of all, my job isn't to say I want to support just this segment of government or society. The job of the Constitution is to provide, that's given to the General Assembly, is to provide an education to all the students in the state of Ohio. And we're actually not talking even in this lawsuit about other children. For example, children who are homeschooled. We don't care less about children who are homeschooled because we're not paying for that. But if part of your question is, well, what do public schools not have that they're lacking that we should have more of? I think they should have more flexibility. I think they should be able to decide for themselves how they pay their teachers. For example, we have a statute in the state of Ohio that says when a teacher reaches a certain level of experience, then their pay automatically goes up. Now, that's not affected by, is the teacher doing a great job? Maybe they should be getting paid a lot more. That's something we consider. But that's a mandate that we put on public schools. And maybe maybe those school districts would have a different way of doing that. And we do have other mandates, and for folks who've been around for a while, they might recall a bill that I introduced called the Public School Deregulation Act in 2017, where we eliminated really dozens of mandates that we put on public schools. Now, keep in mind, the folks who want to do that are superintendents and school boards. The people who don't want to do that are the employees, because those employees join a union because more employees are hired. And so within that sphere, within the public schools, you have these folks, they disagree exactly what should be going on with public schools. So as I said, my job is much more broad, much more complex, I think, than saying we just have to support public schools, because we are. In the first 20 years of this century, public school spending went up, adjusted for inflation, 50% above inflation in the first 20 years, okay? We then had the budget of 2021, record increases for public school spending. We had the budget of 23, record increases for public schools. Now, the General Assembly passed a bill which increased funding to public schools $600 million. And I will tell you that there are some school districts that are very conservative in their spending. Bluffton, Ohio, $12,000 a kid, $4,000 below the average. But there are some other schools that are spending every dime that they have. And so unfortunately, in some of those school districts, you have fifth graders who don't know how to read. So we need to have more flexibility. Let's give money and encourage public schools who are doing a great job. Not just with kids who have two parents and, of course, are likely to be successful, but with all the kids. But when in districts where they are not, where they're failing those children, our job is to help those kids. And if a better job is to have them in a small private school or a charter school or some other function, that's what I want to do, okay?
Hold on real quick. We're going to go to a couple questions online because they've been waiting as well. So
Okay,
reporters
should.
online.
All right. You want to come back up?
For the reporters online, the first question is from Kurt Weinschneider. Sorry if I butchered your name. With the Ohio Midfield News Group.
Okay.
Can you unmute?
Yes, I'm with the River Network, based in Bel Air, Belmont County. And I just want to make sure that I'm understanding how the school funding stream under vouchers work, because I remember the old system where it would go through the district. And if you could clarify and amplify a bit on that, I just want to make sure I have this straight. Does the voucher come directly from the state to the charter school or to the parent?
Right. Yeah. So several years ago, or when this first started out, the concept is that with each child who goes to a public school, they get a certain amount of money per child to go to that district. And we, when the EdChoice was started, what we simply said is, hey, that money that is going to go for that child that's in that school district, we're going to have that school district send the money over to the private school. Now, interestingly, a lot of folks, a lot of districts, I should say, were getting a lot more money than what those vouchers were worth or those scholarships were worth. So in Dayton, Ohio, they'd be getting $10,000 to $12,000 from the state, but sending a voucher or a scholarship check to a local Catholic school for only $5,000. So the Dayton public schools were making money off of the deal. However, for years and years and years, the complaint was brought by the schools only getting $1,500 or $500 per child from the state. We're losing money. We have to send this money over to private schools. Set aside the fact that most of the kids who were using the scholarships were coming from urban schools who were getting big amounts of money from the state per child. So we separated that about 4 years ago and said simply this: if you qualify for an EdChoice scholarship or to the amount of money that you qualify, just apply to the state. And instead of the money, a check being written from the public school to the private school where that child is going, the check goes directly to the parents, or if the parents designate, directly to the school. The parents have control of it. And in effect, it's their money for them to decide if they want to go to the private school. So it is separated from the money that goes to a local public school. Does that answer your question?
Yes, thank you.
All right.
Okay, the next question is from Jaden Jefferson with the Toledo Free Press.
Hi, my first question is for Speaker Huffman, just regarding the program in general. Critics of the program, they argue that private schools are not subject, or non-public schools are not subject to the same oversight as public schools. And so, is there room for this program to be improved? And if so, how?
Yeah, this is a fair argument, I think, that's made on a fairly regular basis. There have been a number of things that we do have that have changed through the years. I'm going to miss some of the accountability measures. Probably Rabbi Frank could come up and list the half a dozen that I missed. But there are, of course, the normal safety and all those sorts of things. But there's also testing for the students who have to take, who accept these EdChoice scholarships. So we see how well they do in making sure that those students are getting, at least on a test, as good of education as they had before. And that I think we also have that in charter schools, but I'm not sure. Rabbi, can you address any of these other accountability measures, or did I get it by and large?
I think you got most of them. I mean, generally speaking, charters have lots and lots of regulations. They're different. They create some flexibilities. But even for charter non-public schools, Ohio, even pre-vouchers, regulated our private schools probably more than almost every other state in the country. That's kind of how it's always been. The state's always been very supportive of non-public education, but it's also been a pretty significant regulator. They have to keep all the same operating standards of Ohio schools, which you can find in the Ohio Administrative Code, and that's what governs most of the broad things that all schools, public and private schools, have to follow. The other thing and then there's a whole host of other accountability measures, but I think that one of the key things to keep in mind is that one of the accountability features that exist for private schools that do not exist, at least yet, in the traditional public system is the ultimate accountability is going to be to parents. And if parents are making the affirmative choice, whether it's going to apply to the state for an EdChoice scholarship, dipping into their own pocket for tuition, they are going to hold those schools accountable. And that is really the ultimate accountability. In fact, if that existed in the public school system, my guess is that there will be people in the legislature that think that's a pretty good way of holding them accountability, and maybe we can get rid of some of the things that most public schools complain about a lot.
Yeah, I would add that, we have other benefits that come from the government that are portable. And of course, the benefit that we give to public school students is also portable by and large. They can take their right or their payment to go to a public school, and they don't have to go to their school district. They can open enroll to another public school. And in fact, open enrollment is the largest school choice program in the state of Ohio. There aren't any lawsuits being filed over it because the public school districts who have all the money for lawyers are not filing those. But if you look at other things that we provide to the public, we have SNAP benefits, for example, and those folks can go to whatever grocery store or other food vendor they want to, who want to take that. I'm guessing that if they don't like that store because they don't like the products they sell, they can go to wherever they want. We don't require them to go to the government store. We don't require Medicaid recipients to go to the government hospital. They get to choose the doctor or the hospital that they want by and large. So this is really no different than that. And so the accountability is really by the user.
The next question is from London Bishop with Dayton Daily News.
Good afternoon. Thank you so much for this opportunity. I had a couple questions. The first is, and I apologize if I missed this earlier, when was the provision that you mentioned about the legislator being required to fund religious schools, when was that added to the Ohio Constitution?
I'm going to guess 1851, but I do not know the answer to that. I got a nod from a knowledgeable person in the room. That's when the big rewrite of the Ohio Constitution, the original big rewrite, let's put it that way.
Gotcha. My second question was, is there a state mechanism for documenting which students are using these vouchers? There's been several studies that have come out over the years of the demographics of students that are using these vouchers. I'm wondering if there's a state mechanism for collecting that data.
Yeah, the state collects a lot of that data. I don't know specifically what you're looking for, but the state collects information on who's using a voucher and including various racial subgroups, obviously income levels, and then it also receives all of their testing data. The EdChoice Scholarship Program requires students to be tested using a set of pre-approved tests that are approved by the Department of Education and Workforce. And so those also can further be broken down according to test results by racial subgroup.
That was the last question online, so.
Thank you, that answers my question. I have, oh.
Thank you all for coming.